several court cases have been filed. They have been ongoing involving Mumias Sugar Company. Of particular interest is the case that is to come up for hearing on the 25th day of January 2022 before the learned judge Justice Okwani. A number of issues have been raised in that application. The plaintiffs or the parties who moved to the court, they are said to be purported farmers. These farmers want the process of processing or the initialization of the processing of the Mumias Sugar Company stopped. The court granted them a stay of 10 days. The court said, let the process stop for 10 days. The parties were given leave or time to file their papers. They have filed. A number of issues have been raised. One of them is jurisdiction of the court to entertain such a matter while there is an insolvency court that has extensively determined on the issue of leasing of the property or the assets of the Mumias Sugar Company. Another question that has been raised in the responses that have been filed in court is the issue of blockers of the parties who are moving the court. In essence, the case filed was seeking to nullify the process of tendering on the issues that it was illegal, it was unprocedural, and it was marred with illegality. The pleadings and the responses filed by the parties disclose that the procedure that ought to be followed when a private company is leasing out assets were followed. The case that was filed before the Public Procurement Tribunal was dismissed on the ground that the parties did not have the proper approach to the court. Similarly, we are asking the court, we the advocates for Gatwamba, who are members of a cooperative that undertakes the farming activities, that it is not in the interest of the farmers that the process that had been allowed by the court. Justice Alfred Mabea last year gave a go-ahead for the receivership manager for KCB, who is one of the security creditor, to proceed and tender or issue float tenders for the assets of the Mumias Sugar Company. So it is our opinion, which has been put across in our pleadings, that the court properly clothed with jurisdiction to determine the matters of a company that is under insolvency is the insolvent court. So we have raised objections to the court that is handling the case being presented by a number of farmers who, in our opinion, we see that they are being used by some of the tenders, some of the bidders who lost in the bid. They are being used to frustrate the operations of the Mumias Sugar Company. The invitation for the parties to tender was issued, and it is clear from the invitation the purpose, and there is a goodwill from the political spheres to revive the company, because it's a giant, so many people rely on it, so many farmers, so many sectors of the economy rely on it. So it is not in the interest of justice to stop a process that has been conducted duly and to the benefit of the farmers, to the benefit of the concerned parties, just for the sake of some few ungrateful, some few parties who feel the process was not done as to what they wished. The tender was issued to the successful bidder. The process of finding a successful bidder is very clear in the law. The procedures were followed. In the Public Procurement Board, the arguments on the tendering process have not found merit. So it is not meritorious for the parties to find proxies to file case in court, to gratify their personal egos in stopping a process that has much public interest and that has been done with conformity with the directions of the court.